second and let me, even though I can't see, I think probably if I close my door, it's better. All right, then I think, are you all ready?
Mhm.
All right, then we're ready to open court.
All right, ma'am, thank you.
The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States in this honorable court.
All right, good morning, everyone, and welcome to the October session of the Fourth Circuit. And Judge Quattlebaum and I, in particular, want to welcome Judge Gallagher and appreciate you serving with us this morning. And so we'll hear argument in our first case, Flexivan Leasing versus the Travelers Indemnity Company. Mr. Pritchard.
Yes, ma'am. May it please the court. Your Honor, can you hear me?
Yes.
Okay. Do you mind if I use my timer on my phone since I don't have a timer like I would normally have?
Can you see the timer on the screen?
No, ma'am, I cannot.
Okay, well, use whatever timer you need, and I can see the timer on the screen, so I'll be sure to keep track of it for you.
I can be able to keep why. Thank you. This is a very complicated matter which arises out of an intermodal chassis accident. And my client, Flexivan Leasing, is in the business of doing two things. One, it leases chassis to shipping lines and others, and it maintains its own fleet. And two, separate and apart from that, it manages intermodal chassis pools, which are collections of chassis which various different shipping lines and others contribute to, and they can pull chassis in and out of the cooperative pool, and they keep a scorecard. Flexivan keeps a scorecard of who has it and for how long, and at the end of each month, they settle it up. The chassis in question, oddly enough, was owned by Flexi, but was on a long-term lease to Zim Shipping Line, which was contributed to the South Atlantic Chassis Pool, which was the IEP, the intermodal equipment provider, meaning basically it was the owner of the chassis for all intents and practical purposes under the federal statutes. And the chassis had been removed from the pool by HIPAG so that it could move a box from...
You know, Mr. Pritchard, you can use your time however you'd like, but I'm pretty sure the court is aware of the factual background if you'd like to get into your legal arguments.
Yes, ma'am, I will. Well, first, I think the court erred in finding the judicial admission in paragraph 4 of the complaint, which is sort of central to this whole case, is whose law applies, South Carolina or New Jersey's?
Well, the complaint did say that South Carolina law applies, didn't it?
There's no denying that that is said in the complaint. It says it straight up, but it's well settled that judicial admissions are a question of law and, the judicial admissions apply to fact and not law. Conclusions of law are not subject to judicial admissions, and choice of law is...
Judge Quattlebaum has a question.
Sure.
Yeah, I tried to talk and was muted, so I apologize. Mr. Pritchard, I appreciate you're correct that judicial admissions are about law. You know, arguably the second sentence of paragraph 4, could be construed as a question of law. What about the first sentence of paragraph 4?
One where it said, I don't have it in front of me. Would you read it, please? I'm sorry.
Okay, I'll be glad to read it. This case involves a policy of insurance issued by Travelers, which insures interest in South Carolina.
I think that in and of itself is a question of law, and I don't think it does insure interests in South Carolina. And I think that's central to this question. I think, is that a question of law? And I believe it is. Whether or not it insures.
So if I could just follow up, I appreciate, it seems, let's see if I can break that down. One issue regard to that is that a question of fact or law? And the second question would be, is it true? Is it correct? It seems to me those are separate issues. I think I understand both arguments, but do you agree just generally that with what I said, that those are two separate questions that we have to look at?
I would agree. And I think
okay.
The answer to
what's the best case you have for the language in the first sentence being a question of law?
Well, whether or not it insures an interest in South Carolina is a question of law, just like citizenship or policy, contractual interpretation, et cetera. I think the question is it an interest in South Carolina? Is in and of itself a question of law? And so the answer to the second question is, I don't think it does. I think it's a question of law, and I think that the court needs to overturn that aspect of the holding, because I don't believe, under the factual scenario presented and under the law presented, that it is in fact a policy of insuring interests in South Carolina, because the insureds are in Kentucky and in New Jersey, and the chassis in and of themselves, which are in a pool, are constantly moving, and so they don't have any fixed situs, really. If you think about it, it could be in Charleston right now, and it could be in. I'm sorry, somebody asking a question.
Yeah, if I could, that's a good question. I mean, if if really, on the question of whether you're relieved from a judicial admission, I think address that question, and the focus on the chassis. I appreciate that argument. That may make that like the Russell case, for example. But is that the only way to look at it? I mean, there is a location in Charleston, and it is at least part of the interest being insured, the management of the locations, one of which is physically in Charleston. Does that differentiate this case from Russell, for example?
No, and here's why. The depot that Flexi maintains in Charleston, all it does is it leases its particular chassis in and out that it owns, usually for short periods of time. For instance, if you've got a particularly heavy haul, we have what we call Flexi Day. So if you're carrying, say, rocks or tile or something very, very heavy, you wouldn't maintain a chassis like that in a pool typically. So you just lease it for a very short period of time. The chassis in question was actually belonged to the pool. It was actually the pool's chassis, and the pool was its IEP. Okay, that's registered. That's a governmental question. It's a question. It's just what it is, like titling a vehicle. The chassis itself, I don't know that it ever touched Flexi's facility in Charleston or any other Flexi-owned facility, because the way these pools work is they actually work on the Ports Authority terminal. So it's almost like, okay, I'm going to drop the chassis in the Walmart parking lot and you come pick it up when you're ready. It's sort of the same concept. And it doesn't go on at a Flexi facility. And most of the work that pertains to the actual chassis pools actually goes on in New Jersey. It's basically an accounting function at the end of the day. Periodically, one would go out and spot audit the chassis on location at the Ports Authority terminal. And the reason one would do that is, particularly in this industry, there's a great deal of fraud with vendors. You know, they'll say they put on a tire and they didn't really put on a tire, and they'll bill it. And I mean, you know, you go out to some of these pools, I mean, it's millions of dollars in loss. But they'll periodically go spot audit the chassis to make sure that the vendor's invoice serial number matches up to the chassis tire, or that there really was a light put in there, or that sort of thing. But really,
Judge Gallagher has a question.
yes.
Because you made the statement you made in paragraph 4 that Judge Quattlebaum was talking about earlier, though, wasn't travelers in effect deprived of the opportunity to take discovery into these issues of whether interests in South Carolina were insured or not?
I know not necessarily. I mean, I don't think that there's really there's anything that would really change this analysis one way or the other. I don't think that there's anything that would have gone on there that could in any way change this. It is what it is. I mean, the chassis is titled where it's titled. The IEP is what it is. Which is a matter of public record. Its relationship to Interstar is what it is. Interstar's relationship to Mr. Vitito is what it is. I mean, there's just really nothing there. The factual patterns really are, to the extent there is a factual pattern, it's set in stone. There's no discovery that really could have taken place that could have changed this analysis in any way, shape, or form.
Mr. Pritchard, I have a question. Because your time's running low, I have a question about exclusion G.
Yes, ma'am.
Your brief at page 57 says that appellee failed to remove exclusion G after having been instructed to do so. Curiously, there's no JA site there. I'd like to know the site to the record for that statement.
Yes, ma'am, I can. If you would give me a minute while Mr. Davis argues, I'll give it to you in my rebuttal. But essentially,
go ahead.
When Interstar contacted Dole, Traveler's agent, to procure the policy, they sent them the Exhibit B and said, we need coverage just like this. Exhibit B, section 1.4 says the automobile exclusion must be removed. And it was not removed, unbeknownst to anyone. In fact, I'll even see if I can find this. I know it's in there. There's an email from Interstar when all this starts coming down. Basically, the president of Interstar says, what have I been buying? Because that's my whole business model. If you put this exclusion in, this policy doesn't even cover me. So that's where the trouble lies. I mean, this exclusion essentially negated all coverage to both Interstar and Flexi. And that's where the whole problem lies. Flexi was perfectly happy with Travelers for 2.5 years, and you didn't know that the exclusion was in there. Travelers never said word one. And then all of a sudden, after 2.5 years of this, boom, we get a reservation of rights letter for the first time, which lets everybody know that this exclusion's in the policy. Now, I mean, presumably Interstar should have known because they'd have had a copy of the policy. But I don't represent Interstar, and I don't know what their thought process was. But Flexi only got a certificate of insurance, which is sort of standard in the industry. And so Flexi had every reason to believe that Interstar was providing the coverage that was requested. And frankly, based on the emails from Dole, Interstar had a reason to believe that it didn't have an exclusion G in there. So I can pull that, yes.
Just to follow up on that, whether or not there's some issue about that exclusion, I appreciate the significance of that to coverage, and I appreciate the concerns. But does that create? I mean, it's still at the point we're in is a reservation of rights situation. And how does that create a conflict under Twin Cities?
Well, at that point, Bernie Vaughn, who was then the executive vice president, starts insisting that that Interstar be brought in as a third party for not providing the coverage that was required. At that point, and where everything started going off the rails, and I've got it right here if you want the actual site. They're told by Mr. Wall that he takes his instructions from travelers, not Flexi, and that Flexi and that travelers will authorize him to bring Interstar in as a third party. I believe my time is about to end. As a third party. So at that point, that's when the wheels come off. That's when Mr. Vaughn says, well, wait a minute, I'm the client here and you're supposed to do what I'm telling you to do, but you're telling me that you take your instructions from travelers. And that's when he says, enough is enough. And that's when he starts asserting the New Jersey law thing. And
All right. Judge Quattlebaum or Judge Gallagher, do you have other questions? All right.
Not for now.
Mr. Pritchard, I realize you were answering Judge Quattlebaum's question, and I appreciate that, but your time is up and you've reserved 7 minutes on rebuttal. So you can look for those sites. Thank you. All right, Mr. Davis.
Thank you, Your Honor. Good morning. As has already been alluded to, this case has been going on for quite some time. A lot has been written, many, many pages. But I would submit that really what it all boils down to is that the issues are pretty straightforward and simple. After all the briefing, I think Mr. Pritchard's done a good job of laying out what the issues are, and I'll take them one at a time. The first one is whether or not there was a judicial admission. I would point out that there's law that says that a simple mistake, if a clerical error or something like that can be corrected. But here, it's really an unequivocal statement that South Carolina law governs, and it even cites to the South Carolina statute concerning the choice of law. So we would submit that there was no mistake here, and that if there was ever a judicial admission, this is it. They've admitted that South Carolina law governs, and aside from the judicial admission, it does govern. After all, notwithstanding the argument about how these trailers move around the country, which is true, the cases that talk about, in the choice of law context, the fact that vehicles are transient, I submit are inapplicable to this situation because the trailer in question was not transient at the time of the accident. It was disabled and was being repaired, and it was in a facility in Charleston. And I think it's important to point out that FlexiVan is kind of wearing more than one hat here, because they were also the administrator of this pool whereby trailers were shared. And so these operations with regard to the port at Charleston were conducted out of Charleston. And so there is a connection to South Carolina, which justifies the application of South Carolina law. And I submit that, therefore, the allegation in the complaint to that effect is exactly
Judge Quattlebaum
correct.
has a question.
Yes.
Mr. Davis, on that point, I'm trying to make sure I understand this as best I can, and because I think maybe certainly if there's no judicial admission, this would be a question. Maybe it would be a question on whether to relieve Flexi of an admission if there was one. But so I'm trying to understand this location in Charleston. What's the connection of the location in Charleston to the claim here? Was the injury to the independent contractor who was doing the work, did that happen at that location, or did he pick it up from that location? And is that in the record?
I believe it is in the record, Your Honor, and I don't believe Mr. Pritchard will disagree with me, but I'm sure when he speaks again, if he does, he'll say so. But my understanding is that there was a facility where these trailers, the trailers are essentially shared as a matter of efficiency. And so, and there, as I understand it, there are various locations where they can be, I guess, stored, for lack of a better word, so that the various trucking companies can share them. And this particular one had the mechanical problem, and so a local repairman went out to repair the wheel, and that's when the accident happened. It happened there in Charleston at the holding facility.
Okay, that last point was the question I was getting at. Thank you.
I believe that's the term that they've used, holding facility or holding something like that. But that's the way I understand it worked. So again, we strenuously would argue that because not only of the clarity of the admission and the complaint, but its reference to the South Carolina statute and the connection to South Carolina that I just described, that regardless of the judicial admission, South Carolina law would govern anyway. Secondly, New Jersey really has no real contact with this dispute. The incident happened in South Carolina. We're talking about the performance of the contract. That's what's at issue. So again, we strenuously submit that South Carolina law governs. On the third point in the statement of issues for appeal, the argument is that the district court erred in holding that Flexivan must prove that there's an actual conflict before it's appropriate that counsel withdraw. And I would submit that, as is stated in the briefs, there's no law to that effect in South Carolina. In fact, while there's no law on point in South Carolina, the procedure that's been followed here for certainly the 40 years that I've been practicing law on.
So if there's no law on point on that in South Carolina, shouldn't we certify a question to South Carolina about that?
Well, Your Honor, that I certainly would not argue against that. We do have some federal cases, as referenced, that address that, but it is true that, to my knowledge, there's no case that specifically indicates what the duties are in that situation. I would point out a quote that I really liked in one of the cases. Court will bear with me just one moment. This is from the Twin City case, where the court said, quote, "We are unable to conclude that the Supreme Court of South Carolina would profess so little confidence in the integrity of the members of the South Carolina bar." And I think that's a fair and true statement. It's well known among the defense bar here that when defending an insured, that the insured is your client. We certainly instruct our young associates to that effect, and that there's a duty to put that client's interests above the insurance companies. And if there is a conflict, for example, if information is learned that could jeopardize coverage, then that is not to be revealed to the insurance company. So I think that's a strong statement from that case, but certainly I'd have to admit that there's nothing I'm aware of that's on point from a South Carolina appellate court, state appellate court. And with regard to the exclusions and the way that travelers handled the defense of this, certainly they reserve their rights, but I would point out that although this exclusion G was referenced in one of the reservation of rights letters, travelers never denied coverage based on exclusion G. Travers did what it was supposed to do. They reserved their rights. They hired a very good lawyer who was defending the case. Um, that lawyer was asked to do something beyond what the insurance company had asked him to do, namely
Excuse me,
assert a
Judge
cross claim.
Gallagher has a question.
Yes.
Doesn't the breadth of exclusion G, though, come close to equating to a denial of coverage? It is a fairly broad provision under the context that was being looked at here.
Your Honor, I agree that it is a broad exclusion, but would I guess my response to that would be that although it is a broad exclusion, all that happened is that the insurance company Travers put the insured or the additional insured on notice of it, but they never denied coverage on that basis. They simply were dotting I's and crossing T's as they should do in putting the insured on notice of any exclusion that could at some point possibly be applicable. But again, Travers never relied on it. All they did was to reserve their rights.
Following up on that, I'm trying to, certainly there is an important issue of coverage that is implicated by the reservation of rights letter. And so if that's the case, is that the issue though? Conflict isn't the issue whether or not Mr. Wall is able to represent Flexi in this case. Isn't that the primary? There's a difference in whether there's coverage and whether he is willing to represent the defendant, it seems to me. Is that correct?
Yeah, yes, Your Honor. I do agree that with that. And certainly Mr. Wall was hired by Travers and was being paid by Travers. But, and this sort of goes back to the point I was making earlier, his client was Flexi. And so he was hired to do his best to defend them and was doing so until he was fired. The conflict arose when Flexi insisted that he assert a cross-claim. And I want to emphasize that Mr. Wall did not refuse to do that. His response was that he would be happy to do that, but that the insurance company would not pay him to do that because his job, according to what he was hired to do by Travers, was to defend the case, not assert a cross-claim. But he did say that he would do it if Flexivan would pay him to do it. And rather than do that, they fired him. And so I would submit that that Travers did what it was supposed to do. They hired competent counsel. They were to pay him, and they couldn't control the fact that their insured or the additional insured decided to fire him and not to pay him. And certainly, I'm sure it's not a situation where Flexivan couldn't afford to pay him. So that was their choice. They could have paid him to pursue that cross claim if they had wanted to. Instead, they chose to fire him, and that's how we've ended up years later where we are now. So continuing with my argument, yeah, again, I really can't improve on Judge Norton's orders. He really, in those orders, that's our position. As he said, there was a hypothetical conflict, but there's no basis under South Carolina law that the failure to bring a third-party cause of action creates a conflict that requires termination of the relationship. And of course, I think he cited that Twin City case. So, all things considered, our position is that Travers acted entirely appropriately and in accordance with the law and custom by hiring a very good lawyer who was pursuing the defense actively. And this whole problem and all these years of litigation arose because FlexiVan, instead of choosing to retain Mr. Wall to pursue that cross-claim, chose to fire him instead and retain new counsel. That's where the problem arose. If they had just done what he had suggested, then they could have challenged Travers' decision, if there had been a decision, not to pay him to do that in a separate suit. So as far as we're concerned, that's a situation where they made their bed. So I see I have time left, but I think I've addressed most of the main points I wanted to make, but I'm certainly happy to entertain any other questions.
Judge Quattlebaum or Judge Gallagher, do you have further questions? No? All right. Thank you, Mr. Davis. We understand your argument.
Thank you, ma'am.
And we'll hear again from Mr. Pritchard.
I can now see the timer on the screen has come up. In response, Your Honor, to your earlier question with regard to references, starting on page 491, there is an email of 9/24/2009 from Interstar to W.P. Dole, where they say, please see the attached agreement. And so unfortunately, you have to run through several pages beyond that to know what the whole agreement is. But the entire agreement is actually the master maintenance chassis agreement. And that basic email chain ends on page 509. Then on 510, they note that they've faxed it. So you jump a couple more pages, and then starting on page...
That they faxed what, the agreement?
Well, the Exhibit B, which is the essential...
And Exhibit B is what?
That's to the master maintenance chassis agreement, which sets forth the insurance requirements.
Okay, and so where is it that in the record that shows that appellee failed to remove exclusion G after having been instructed to do so? Because that's what your brief says. Yes,
there are two places. On page 520, that's okay. I'm going through it to 521, where they actually faxed the exhibit over. That's where they were instructed to do so. It's all in that chain that I just cited for you. Then you jump a few more emails later, and on page it's unfortunately a series of things that you have to go back and forth between to get there. It's pretty obvious once you read it. Getting you the next page site, which is important.
Okay, so we need to piece together these various
yes, it's a series
faxes and emails to find where they were, quote, instructed to remove exclusion G?
Yes, I just gave you the email site, the page site, where they sent the Exhibit B over and said, we need insurance that conforms to this. And then on page 535, Dole responds on the same day in an email where they say, jump through it, but it says, here's the certificate of insurance. And they go down and they say, at the bottom of the paragraph, at the bottom of the page, not sure what item 1.4 references, and you do not have an exclusion for this, but not sure if there's any way for you to verify your subcontractors do not. So they've acknowledged that they've seen this section 1.4. Well, the fact that that reservation of rights letter of March 27th, 2013 was written bringing up exclusion G is indicative of the fact that travelers never removed it. And it's in the policy, it's at the beginning of the record, exclusion G is right in there. And that's why they raised it to begin with in the letter. So they were told to take it out.
Right. I see that it's not taken out. It's just not as readily apparent to me, and perhaps I need to look through more closely what you've just cited. It's just not as readily apparent to me that they were, quote, instructed to take it out. But regardless, Mr. Davis said that his client did not rely on exclusion G to deny coverage. What's your response to that?
My response to that is I think that's somewhat illusory. I mean, I've struggled to believe that after 2.5 years of being involved in this case, suddenly one day they just woke up and went, aha, maybe we just ought to just throw this out there. I mean, at this point now they're starting to figure out that they've got a fairly significant brain injury case and that they've got an exclusion that's going to get them out of it. I mean, why bother to write the letter if you're not gonna rely on it? It was pretty clear where this was headed. I mean, I don't think anybody. I would love to present to a jury. I'd love to hear them to explain that they threw that reservational rights letter out there, but they were just kidding. I mean, they meant it, and I think it's pretty obvious to all concerned that they meant it. They wouldn't have raised it if they didn't think they had a valid basis for denying coverage on a multi-million-dollar brain injury case. I think that's ultimately where this went. Judge Quattlebaum, just to clarify the chassis and where it was actually on Intermodal Bridge Transports Yard, that's IBT. They are an intermodal drayage company. They had outgated the chassis from the port about 3 or 4 days before, taken the box up to North Carolina on that chassis. The box had been stuffed with, I believe, paper, rolls of paper. It had gone back to the IBT yard. No one knows quite when the tire went flat, probably went flat on the way back. The driver might not know. He grounds it in the yard. They have to move that chassis and box over to the port that morning because it's going to get on a ship and go to Antwerp. And during the process of going to get the box and the chassis, the driver discovers that the tire's flat. So that's when they call Interstar, who calls Mr. Vigata, who comes to fix it. And so it can then go to the port and then go on the ship and then go over to Antwerp with the paper in it, the box, that is. The chassis will, of course, be left at the port until it got outdated again. So that's
okay. So it was the work done to fix it once it got back to the holding area or the port or whatever the actual name is?
Well, IBT's yard. IBT actually had possession of the chassis at that time. They were hired by Lloyd to move a box from Charleston to North Carolina and then back to Charleston so that they could go on a ship. And so IBT, the driver got in at night and nobody was there, just grounded the box and left, which is not uncommon because you can't get on the port after 5 o'clock, but you can get in and out of the intermodal drayage lot all hours of the day and night if you've got the access to it. And that's the service that they provide as an intermodal drayage company. So that's what really happened there.
Thank you.
Thank you.
All right. Thank you. Thank both counsel on behalf of the panel. We appreciate your arguments here today and the extra time you've taken to address our technological needs in this time of pandemic. And we wish you a good weekend.
Thank you.
Thank you.
Thank you. And we'll move on to our next case. Thank you.
Thank y'all.
The court will take a brief break before hearing the next case.
in the second case, which is Humane Society versus United States Fish and Wildlife Service, and we'll hear from Mr. Mullen.
Good morning, Your Honor. May it please the court. There are three principal issues framed by the briefs in this case. The first is whether the Fish and Wildlife Service is obliged by the Freedom of Information Act, or more specifically, the reading room provision of FOIA, it's called eFOIA, to post certain documents to its website without prior request. The second is whether the court is powerless to enforce eFOIA, as the service contends. And the third is whether the service successfully evaded a ruling on its eFOIA obligations when it produced and posted certain documents after it was sued. The documents that are at issue in this case are related to the enforcement of the Endangered Species Act and an International Convention on Trade in Endangered Species. Before anyone can import a lion or elephant trophy from Africa, the importer has to obtain a permit from the service, and before the service can issue such a permit, it's got to make a finding, among other things, that hunting the species in the country of export will enhance the survival of the species. Those finding documents, the applications that trigger the findings, and the permits that the service issues, those are the documents that this case concerns. Each category of documents that I just mentioned is covered by a separate provision of eFOIA. I'm going to deal first with the finding documents that the service issues. Those documents are final opinions rendered in the adjudication of cases. That's one of the statutory triggers for mandatory posting under eFOIA. That's statutory
Counsel,
language. Yes, Judge. Judge Quattlebaum.
Could I stop you? And I appreciate your argument that the findings and permits are opinions and orders, but it isn't the issue here that whether they're opinions and orders under A through C, or whether they're documents that fall within subsection D, that the agency has responded to the request, and so I know there's an argument about whether they fully responded. Put that aside for the second. They've responded to your request, so it seems to me a debate about whether these are opinions or orders or not. Or my question is, how does the debate about whether these are opinions and orders or not, regardless of how it's decided, even if this is decided in your favor, get you more documents pursuant to your request? Does it get, if they withheld any based on that issue?
Well, thank you for the question, Your Honor. And I think it does get at least one of the very central questions in this case. I think that the government has mistaken the purpose of this litigation from our perspective. It has almost nothing to do with the specific set of documents that we requested, my clients requested, under A3, which is the traditional sort of request and response aspect of FOIA. We've had a long history with this agency of requesting documents, them stonewalling, us having problems getting documents. That had almost nothing to do with this case. This case was brought. Go ahead, Your Honor, I'm sorry.
Go ahead, I'm sorry. No, you finish. I'm sorry.
This case was brought to establish the eFOIA obligations, not the request and response obligations of the agency, but the eFOIA obligations to post documents as they're created, routinely created and statutorily mandated documents as they're created going forward. The agency insists, yes, Your Honor.
Well, that may be your purpose, but to look at what you requested, I think we got to look at the relief you requested. And if you look at the relief you requested, you have one declaratory claim, and that claim isn't, as I read it, that these documents fall within, A2, A through C, or that these documents are opinions and orders. Your relief, the only declaration you sought was that they violated FOIA, and so that they have violated FOIA, and so I'm not sure I understand. I appreciate you saying that's the purpose, but if you haven't asked for that specific relief, and you have the documents that would result from that type of declaration, how do we have a controversy in this case?
Well, Your Honor, we do say, paragraph 98, that copies of permits issued and enhancement and non-detriment findings must be posted online because they qualify as rules, opinions, orders, policies, or interpretations. If the prayer for relief section of the complaint was ambiguous or too general or whatever, that's subject to repair. That's not, you don't get dismissed on lack of jurisdiction under those circumstances. The government.
Well, I mean, I think, I'm sorry, let me just follow up.
Sure.
You're exactly right about there's no doubt you pled that these documents constitute opinions and orders. I grant you that section, but you cited it to me. But if conceding, you also pled that they are subject to production and e-filing under D, and then they were responded to the request. So at this juncture, I'm still not understanding how what you say the purpose was would get you any more documents pursuant to your request.
Well, what it will get us, Your Honor, is compliance by the agency with its e-FOIA obligation to post these documents as required by e-FOIA on an ongoing basis. The government's best case, the case they rely on most heavily, is the Crew case from the D.C. Circuit. And even the Crew case acknowledges that the statute provides for the ability of the district court to order prospective relief. That is to tell the agency, you've got an e-FOIA obligation to post these materials, to provide these materials on an ongoing basis. Now, Crew was mistaken, in my view, for a lot of reasons we can discuss, in limiting that to putting us essentially on a mailing list that the government's got to send them to us, but doesn't have to put them on the website. I'll grant you that. We can talk about why Crew was in error there. But, Your Honor, I'm looking at the relief requested on page, let's see, it's the 65 of the joint appendix. Order the defendants on an ongoing basis to make all these documents available via their online reading room. So we are asking for the prospective relief, and we're saying that the agent, it's alien to me, Your Honor, that an agency can say that we've complied with one provision of the act, and therefore you have no complaint if we failed to comply with a second provision of the act. My clients currently, in order to get these materials, have to use A3. They have to file a request with the agency, have correspondence with them over the course of months and years. It's taken years for us to get these documents. Ultimately, we get some, not all. There's a factual dispute that, frankly, is a red herring in this case. I think it's a hair on the tail of the dog. We have a right to have the agency comply with its e-FOIA obligations. We have a right to prospective relief that requires them to comply with that obligation.
So I want to go back to, I think, following up on what Judge Quattlebaum was asking you. Where do I look in your complaint to tie together what you're arguing now for this prospective relief?
Well, again, I'm on page 65.
The government needs to, pardon?
I'm sorry, I didn't mean to interrupt you, Your Honor.
Go ahead, I think you were directing me somewhere.
Paragraph C of the relief requested provision on page 65 of the appendix. To make all these documents available in a timely manner after receipt or creation of the records in the agency's online reading room, consistent with e-FOIA.
So that's the prayer for ongoing relief, correct?
Correct. That's correct, Your Honor.
Okay. So I hear you.
Okay.
on that basis, and we may need to talk about maybe we can separate the claim for current relief versus ongoing relief. Do you concede that with respect to the existing request for documents, that declaring the findings to be opinions and orders would not get you any more different response?
I'm happy to concede, Your Honor, that they can't give us the documents they've given us anymore. We have the documents that they gave us, and they posted the documents that they posted. Now, there was that.
Well, and also the district court found that your request had been fulfilled.
Yeah.
So
again, Your Honor, I think that this is such a minor detail in this case. I hate to belabor it, to spend a lot of time on it, but we came to the hearing.
If your request had been fulfilled, then this is for sure moot.
They haven't been. We came to argument on the motion to dismiss. The government produced and posted a bunch of documents.
With that binder.
The night before, and I came to the court, Your Honor, with a binder of documents that had been produced to us on a disc, but hadn't been posted. And I offered to give it to the judge. I said, they still haven't complied. And he said, I'll take your word for it. The government hasn't denied that this is the case. And so I'll take your word for it that they haven't posted everything. Then we got the decision that said that they posted everything. It was most strange, Your Honor, and a great disappointment that I hadn't been sufficiently convincing. But this case, again, the idea that the government has said we have no...
What about the government's sworn declarations that all known trophy records from January 1st, 2016 forward have been posted online? Do you have anything to counter that?
We're on a motion to dismiss. Yes, we submitted a declaration, and we also had my representation to the court the morning of argument about the state of play, which the court accepted. And then the decision was contrary to the court's representation to me. But again, this case involves an agency that says we have no obligation under eFOIA. Even if we have an obligation, you can't make us comply. We don't intend to comply with it in the future. And that's what this case is about. Yes, Judge Quattlebaum.
Yeah. And I know I may have been responsible for keeping you from getting to that point. So, but we're at it now, and I'd like to discuss that, please. And I appreciate. I think what you're saying, getting now into, is your request for a order of injunction to produce documents on an ongoing basis.
Correct.
And so let's talk about that. The district court. Said that the language of D3 largely suggested that was not an appropriate type of relief for it was not appropriate relief for a relief under subsection D. I appreciate that you could argue, well, we're requesting it under A through C too. And I think that's what you were getting at earlier. But if I look at A4B, the statutory provision that allows for injunctive relief, it only talks about injunctive relief to enjoin withholding of agency documents or improperly withheld documents.
Right.
And that language seems to me to imply strongly the existence of existing documents, because how can they be withheld if they don't exist?
Well, again, Your Honor,
so it seems to me you may want, and I understand why you want it, don't get me wrong, the relief you're talking about, but I don't think that subsection I'd like your response as to whether that subsection does it. And if it doesn't, it seems like the way you would have to frame this is to request documents only under subsection A. Somehow you have to, the way this case has progressed may prevent you from doing it here. And I'm not criticizing that at all, but I'm just suggesting that if we don't have the ability to do future injunctions, and I know you think we do, the way I don't see how we have standing to do it here.
Well, there are a couple things, I think, Your Honor.
Yeah.
Forgive me if my thoughts on this are a little disjointed because I'm trying to put it in the frame of your question.
Yeah, and that may have been Go ahead.
So far as I know, no court other than the district court here has ever said prospective relief is unavailable. The two cases I think that we look at here, both cases on which the government relies heavily, are the Crew case, which I've just discussed, which explicitly, unambiguously says that A4B, the remedial provision of FOIA, does permit a prospective injunctive relief requiring the agency to produce records as they're created. So that's their best case. The other case on which they rely heavily is the Lipton case. The Lipton case wasn't an opinion and order case. It had to do with the frequently requested documents provision. And I think it was Judge Bates in the District of Columbia. This is the EPA administrator. And a media organization said every day that a new calendar entry is created, you should have to provide it. You should have to post it. And the court said, I can't do that. Number one, the statutory trigger is it has to be substantially the same as documents that have been released in the past. And how do I know whether they're substantially the same unless they have been created and I can look at them? That's number one. Number two, how's the court going to know, or how is the agency going to know whether an entry on a particular day is subject to an exemption? It may contain some confidential proprietary information, third-party information. It may have personnel matters that are subject to an exemption. I can't order the EPA administrator on an ongoing basis to post online documents that have been created because they're subject to all of these differences, these day groups. None of that applies here. What's in these documents is there because Congress has said it must be. These findings are defined by law. The permits are defined by law. The applications that we're discussing are on pre-printed forms. There's no argument. Yes, Your Honor.
Oh, yeah, Judge Quattlebaum, did that answer your question?
Yes, thank
Do
you.
you have any? All right, Judge Gallagher, do you have anything further at this point? All right, thank you, Mr. Mullen. You have some time on rebuttal. You have 5 minutes on rebuttal. Thank you. We'll hear from Ms. Yang.
Thank you, Your Honor. Good morning to you all, and may it please the court, Assistant United States Attorney Catherine Yang on behalf of the federal agencies. The judgment of the district court should be affirmed because the claim concerning the posting of existing records is moot, and plaintiffs cannot separately obtain injunctive relief for records that do not yet exist. The amended complaint in this action sought to have the agency post the existing records at issue here to its FOIA reading room. The agency did just that after plaintiffs submitted additional FOIA requests for those records, because with those new requests, the agency determined that the requirements of A2D had been met, which triggers the obligation to post them online in the first place. So the through line of plaintiff's brief and an argument today, essentially that the agency refuses to comply with the reading room provision, is wrong. The agency complied, and here complies, by posting records when they become frequently requested. I would add, too, that this is not new or unusual behavior by the agency. At various points in 2018, even before this lawsuit was ever filed, the agency had been posting material of this very sort to its online reading room, and it continues to post those records online to its reading room when they become frequently requested. The agency did so most recently in June of this year, but also previously in July and September of 2019, and as I noted, even well before this lawsuit ever was filed. So the district court correctly determined that the agency's posting of these documents mooted the claim, and there was nothing left for the court to do. Now, I understand that plaintiffs have invoked the voluntary cessation doctrine in their papers, so I'll address that briefly here. The agency's compliance with FOIA isn't some bad faith litigation tactic. The agency posted the records here because the requirements of A2D had been met. that's not ceasing anything. That's affirmatively complying with the statute once the requirements have been satisfied. And I would note too that this was all brought about because the agency.
Sorry, I have a question.
I'm sorry, yes.
So you're saying the agency is monitoring to see when a particular set of documents becomes frequently requested and then posts it when it meets that standard. But the agency is holding to its position that the findings and permits here do not constitute opinions and orders triggering eFOIA obligations otherwise?
That's correct, Judge Gallagher. And we believe that the relief requested, which is the posting of the actual records, has been satisfied, which moots the claim and removes any obligation for, or really any jurisdiction for a court to then determine, well, should these materials have been posted under one provision or another provision. The fact is that the agency has been complying with its reading room obligation and has posted the records. Yes, Judge Thacker.
But opposing counsel also suggests that the relief they're requesting is that the agency proactively publish these documents going forward. What about that?
Yes, Your Honor. That injunctive relief is premised on a claim that has already been mooted by plaintiff's own actions here in submitting additional requests that then satisfied the requirements in A2D. There's no remaining cause of action. There's no remaining claim. The only thing that's left is a request for a standalone remedy, or otherwise a remedy for a non-justiciable claim. And the courts can't order that remedy in the absence of a live claim. We also know, just as an aside, that this is the right holding because this court repeatedly has confirmed that its job is not to oversee agencies' day-to-day management or overall compliance with programmatic statutes, statutory mandates. Instead, there needs to be a specific justiciable claim that forms the basis for a specific request for relief. And if there's not, then the agency, or excuse me, the plaintiff can't just pursue the remedy in its own right. Yes, Judge.
Yes. So I think I understand what you just said. There's an issue that I was discussing, or your colleague was talking about whether future relief is permissible under the statute. But I want to go back to what I think you said and make sure I understand it. Are you saying that aside from that issue, if there's not a viable remaining cause of action, you can't get that relief anyway? Is that what you're saying?
That's right, Your Honor. It derives from the longstanding requirement that there be a live case or controversy in a particular action. If there's no live claim, then there's nothing with respect to which a court may order relief, relief existing on its own absent some sort of claim for it to decide. And here the claim has become moot, which leaves the court nothing left to do. So I would just reiterate that this. Oh, I'm sorry.
Sorry, just a follow-up question. So how could these entities ever challenge the sort of ability of how could they ever make the challenge that there's a ongoing responsibility of the agency to post these documents without them having been requested? It seems to me that under what you're describing, that issue could never reach the courts.
There would need to be an allegation that there has been a violation first of the statute. And without that allegation of a violation, you can't, just pursue the standalone remedy.
But you're defining violation. Oh, sorry. Go ahead.
Yeah, I'm sorry. Go ahead, Judge Gallagher.
I was going to say you're defining the violation as being the failure to produce particular documents. Here, as I understand it, the entities are challenging the ongoing obligation to post records in perpetuity. So it's not with respect to particular documents. Under your theory, wouldn't the agency always be able to moot it by turning over particular documents and then not allowing the entities to raise their broader challenge?
No, Your Honor, and I don't think that that's the application of voluntary cessation or mootness to these types of FOIA claims. There's been very little case law developed with respect to the application of mootness in a FOIA reading room provision case, and I think that's and the only one that I'm aware of is the DC Circuit's recent decision in the PETA case cited in the papers, there, the decision made clear that that mootness becomes an issue for an agency when the agency has demonstrated that it previously posted posted a set of records in its reading room, and then decided, you know what, despite us having complied with the statute in the past, we're going to take them off. We're going to remove them from the website. We're not going to, we're not going to comply with the statute. And a plaintiff brings suit to say, no, you have to, you have determined that these are documents that must be posted online. You have to comply with your obligation to post these documents online. If the agency then at that point comes in and says, you know what, we're just going to put them back on and we're good to go here, that was the problem that arose in the PETA decision. That's certainly not what's happened here. Again, I point to the history of the agency's actions, which is that even before this lawsuit was ever filed, materials were already being posted online, and they continued to be posted online even without any sort of court order to do so to this day. I hope that addresses Your Honor's question. In the opening argument, there was mention made of this binder of records that plaintiffs say doesn't actually mean that the claim in this case is moot. So I'll just address that straight on. Your Honors, respectfully, I don't think there is any real factual dispute over whether this claim is moot or the completeness of the posting. As Judge Thacker observed, the agency has submitted 2 declarations confirming that it posted the records at issue here, and also swore that it wouldn't take those records down from the website once they were posted. As I also noted, the agency continues to post these types of records online, even without any sort of court order to do so. The records that plaintiffs say are missing, they've never told the agency what those records are specifically. They haven't filed anything with the district court or with this court identifying what those records are. And so
what about the binder that they tried to submit to the court?
Yes, Your Honor. My understanding is that the court did not make a finding one way or the other. The quote that my colleague cited was, it seemed to me, I wasn't present at the hearing, but it seemed to me a passing remark at the very conclusion of the hearing after the proceedings had ended. But again, there was no fact finding done there. Plaintiffs certainly could have subsequently submitted the materials in that binder to the court on its docket. It could also have done so with this court. It hasn't. So the agency has no way of following up on that allegation. And then in the meantime has gone back and double checked and reconfirmed that it's posted everything. So this isn't the kind of clear evidence that would undermine the agency's declarations, which is the standard that the DC Circuit established.
Yes, counsel, I want to go back to the request for an injunction about compliance on an ongoing basis, and particularly the claim that the issue about whether that, aside from the mootness issue, is something that is allowable under the FOIA statute. What's your position on that? Assume for the sake of discussion only that we find against you on the mootness issue as it relates to the future injunction. What's your position as to whether that type of relief is permissible under the statute?
Yes, Your Honor. And this brings us to the other jurisdictional issue that's at play here, although not the one that was squarely presented by the district court's opinion. Our position, to answer you directly, Judge Quattlebaum, is that FOIA does not create jurisdiction for courts to order agencies to post documents online. The DC Circuit, which is the circuit with the most extensive FOIA experience, has held for more than 2 decades in unanimous decisions that courts don't have this jurisdiction. The Southern District of New York recently adopted those decisions, and that case is currently on appeal to the Second Circuit. I understand that plaintiffs criticize the thoroughness of the discussion in the Crew and Kennicott cases, but those decisions considered all of the same arguments that have been raised here, and it still concluded that Congress specified the type of judicial relief that was available to be production to the complainant, because the remedial provision is focused on relieving injury suffered by an individual complainant, not some sort of general injury to the general public. I acknowledge, of course, the Ninth Circuit came out differently last year in a 2-1 decision. I would note that the dissenting judge in that decision found the unanimous decisions by the DC Circuit persuasive. And respectfully, our position is that the DC Circuit decisions are the more persuasive ones. I'm happy to go through in more detail the textual, structural, and contextual indications in the statute for why this is the proper reading, if it would be helpful. But just as a high-level overview, the text readily supports this interpretation. Judge Quattlebaum, as you mentioned earlier, the language of the statute it refers in the past tense. It refers to documents improperly withheld, which indicates that these documents have to be in existence first. And the reading that the agency advances and that the DC Circuit held is the right interpretation, is the only reading that doesn't create any surplusage, because the second clause of A4B, order production of records improperly withheld to a complainant, specifies the meaning of the first clause, which is to enjoin withholding. The reverse reading would read the second clause entirely out of the statute, because the first clause about enjoining is so broad that it necessarily encompasses the relief indicated in the second clause. So that would make the second clause completely unnecessary if Congress really meant them to mean two different things. There are also contextual and structural indications in the statute, including that the statute elsewhere uses the term withholding to refer directly to withholding from a complainant. And in another section of the statute even differentiates withholding on the one hand from making records available to the public. So again, we think there are ample indications in the statute to suggest why this is the appropriate reading that limits the availability of relief to be production of records to an individual requester, as opposed to ordering agencies to post materials online to the general public. Yes.
One follow-up. Judge Gallagher asked a question to you earlier about, what's to prevent an agency from, refusing to produce documents. A lawsuit is instituted, then you produce them and you moot them and you never get to the issue. And I appreciate your position that record is not, the record before us. But do you concede that in that type of record, if there was evidence that would create potential standing, to assert a claim, if there was evidence of a pattern of refusing to produce documents and then mooting the claim over and over?
I think there would be a difference between the question of whether there's the right to seek judicial review, which is available in A4B, and the separate question of what kind of relief would be available in that type of judicial review. So if a violation of A2 had been pled, certainly the plaintiff could seek judicial review of that claim. But in terms of the specific relief that they could be entitled to and that the court would have jurisdiction to actually issue, that's the separate question that A4B says is limited to production of records to a complainant, as opposed to ordering general posting online.
So you would say that you could get relief for specific documents, but you couldn't get the future ongoing injunction. Is that what I'm understanding?
That's correct, Your Honor.
All right.
And I think it also might help to note that although Congress decided not to create the judicial remedy of ordering agencies to post online, that doesn't make the posting obligation, illusory or a mere suggestion, as plaintiffs have suggested in their briefs. Congress wrote into the statute other remedies to deal with instances where agencies are not complying with their FOIA obligations. It says that materials that should have been posted under subsection A, which is the one dealing with final orders and opinions made in the adjudication of cases, it says if an agency is not posting those documents, it can't then use those records against a party. And so Congress created specific remedies to address issues where there are questions about compliance, but it just didn't create the judicial relief that plaintiffs are requesting here. With my final time, I'll just move very quickly to an issue that came up in the opening argument and more recently in the 28J letter that was submitted to the court this week. And this is the issue of the meaning of A2A about final opinions and orders. Now, first, let me just say that I don't think the court needs to reach this question at all because of the mootness and the jurisdictional issues, and also because the district court didn't decide these issues. But because it's been emphasized, I'll just make a couple quick notes. Courts have specifically held that this provision refers to Congress's efforts to protect against the creation of secret agency law. Now, my colleague has focused on this language of adjudication, which is in the statute, but the language in the statute is actually adjudication of cases. And the inclusion of the limiter of cases has to be meaningful, because if Congress really meant A2A to mean literally anything and everything that an agency adjudicates in its normal business, then they would have just stopped right at the term adjudication. This is the mistake that plaintiffs make in their briefs, and in the 28J letter submitted this week, they stopped right at adjudication. But Congress didn't stop there. They said adjudication of cases. So the cases requirement has to have some meaning, and courts have held that the cases requirement involves some sort of adversarial component with another party. To that point, plaintiffs admit there's nothing adversarial about the permitting process here. I don't think that's really a dispute at all. And taking a step back, this cases requirement also makes a good amount of practical sense. If A2A really means all run-of-the-mill permitting decisions that agencies make in their respective areas, then even within the Department of the Interior alone, that would include things like camping permits on national park land. That's also something that agencies decide or adjudicate in that sense of the term, but plainly, that's not something that's creating any sort of agency law or being issued in the adjudication of cases. And my final point is just that the Franks and Markham cases that plaintiffs rely on pretty heavily in their briefs, which came out of the DC District Court, they actually tell us exactly why these materials don't fall within A2A. The Franks case says that these permitting decisions don't bind future applications. They don't even bar the same plaintiffs from filing new applications, so they have no future effect. That is the case here too. So I see that my time is up. I'm happy to address any other questions, but if there aren't, I'll just ask that the court affirm the judgment of the district court. Thank you.
All right, thank you, Ms. Young. We'll hear from opposing counsel again now. Mr. Mullen.
Thank you, Your Honor. Very quickly, I'm hearing something, the counsel has described a relationship between cause of action and relief that is, if not certainly unusual and maybe unique to the law. It would read, if applied broadly, it would read out the entire provisions of the federal rules on TROs and PIs. I mean, the idea that there has to have been a historical violation in order to have a cause of action, which the agency can make go away magically after being sued in order to deny the right to relief, is something that is foreign to the law so far as I am concerned. The agency has insisted it has no e-FOIA obligations with respect to these documents. It doesn't intend to post them in the future. It can't be enforced. It can't be forced to post them. And that is a live controversy under any conception of the case or controversy requirement. It simply is bizarre to me that the government would argue that it is moot, the agency's prospective compliance with the statute, particularly with respect to orders and opinions, is mooted because the agency has, with respect to a specific finite set of documents, complied with subsection D, which is the only subsection they seem to acknowledge. With respect to the remedial powers of the federal court, the court can look at the Ninth Circuit opinion, can look at Crew. The weaknesses in Crew are evident. And I just mentioned a couple of them. First of all, when A4B, the remedial provision, was initially put into FOIA, it was tagged on to the end of A3. it was part of the request and response part of the statute. And so the government argued in case after case that there was no remedial provision with respect to the reading room requirement. Congress came back in 1974, broke that language out, put it in a new subsection, and the Senate report says the reason they're doing that is to stop the government from arguing that reading room relief is not available. That's number one. Number two, the Bannercraft case, we don't have to speculate about the court's equitable authority to remedy things that are not specifically mentioned in A4B. We think it's there. The court can make its own determination. But we don't have to speculate about whether the court has equitable authority that extends beyond A4B, because in Bannercraft, the Supreme Court said that there's nothing, and I have the quote here someplace, the court says there is nothing in section A4B, 552 A4B, the very provision that's at issue in this case, to suggest that Congress sought to limit the inherent powers of an equity court. The courts in this country have the inherent authority to remedy statutory violations by agencies, and the court has for 200 years had the principle of law. The government is looking at this through the wrong end of the telescope. They say because websites aren't mentioned in A4B, Congress must have intended to deprive the courts of the authority to remedy a violation of eFOIA. That looks at things through the wrong end of the telescope. In fact, for 200 years, the principle has been that Congress knows how to limit the equity power of federal courts, that when it wants to do that, it has to do so explicitly. Those principles were played out in Bannercraft specifically. The argument was made there that because A4B didn't provide for the injunction that the plaintiffs sought, it was beyond the authority of the district court, and the Supreme Court said, no, we have 200 years of history on this very point. We've cited those cases in our brief. The idea that the government can say, we know there's this website obligation in the statute. We don't think these documents are covered, and we're going to put you on this Mobius strip where you request documents, you sue us, we produce the documents, you will never get to the point where there's an adjudication of the government's obligation to post. It is a remarkable assertion on the part of the government here. One thing, I spent all my time previously talking about the jurisdictional equitable issues and responding to the government now. With respect to this adjudication of cases point, the government wants to insert new language into the statute. That is, it's not just an adjudication. It's not just an adjudication of cases, but it's an adversarial adjudication. There are two answers to that. First of all, it's a defined term, which the government doesn't even acknowledge in its brief. Second of all, in NLRB against Sears, the question was a reading room case. The question was whether the government had to put in its reading room decisions by the NLRB General Counsel whether or not to pursue a case, whether or not to file a complaint. If the complaint had been filed, it would have been adversarial. But the decision whether to file the claim was not adversarial. In our view, this court can resolve this case by reading two cases. NLRB against Sears and the Bannercraft case answer both the substantive gateway issues, are these documents covered by eFOIA, and the question whether the courts have the authority to enforce eFOIA, or conversely, whether the agency can thumb its nose at its statutory obligations and proceed without compliance. My time has long since elapsed. I'm sorry, Your Honor, for belaboring the point.
All right, thank you. And on behalf of the court, we thank both counsel for your arguments today. We appreciate the work you put into the case, and we'll take it under consideration now and wish you both a happy and good weekend. I don't know about where you are, but the sun is shining spectacularly here in West Virginia. So
don't
enjoy.
rub it in, Your Honor. Thank you.
Thank you.
You can visit it.
All right.
All right. Thank you. We'll
Thank you.
adjourn court until Monday.
Thank you.
This honorable court stands adjourned until Monday. God save the United States and this honorable court.
Judge Thacker?
Yes.